Please the court.
Yes, sir.
Your Honor, we will acknowledge receiving a copy of the indictment, acknowledge that Kathi Adams is the person named in the indictment, waive a formal reading, ask the court to enter a plea of not guilty on her behalf, and ask the court to set this for further proceedings at the court's pleasure.
All right, the bond, thank you. The bond in this case is, Pam, what is it?
$10,000.
Pardon?
$10,000.
$10,000, full cash. Are you going to stay in this case, Mr. Locke?
I am going to stay in this case, Your Honor.
All right, thank you. Bond will remain at $10,000. The court's experience with Ms. Adams is that she has a real problem obeying the court's orders. I will consider a modification of bond, Mr. Locke, by motion, notice to the Commonwealth, on the condition that a long-term out-of-state rehabilitation program is an option. Ms. Adams, you've been in custody for how long now?
135 days,
135 days. How long have you been sober?
6 months.
All right. How you feeling?
Okay, yes.
When was the last time you saw your children?
September.
When?
September 4th.
Right. Have you asked to see them or asked to have them brought to the facility to see? Is that possible here in the county?
I've asked.
Right. And how are they doing? Do you know?
Don't know. Although their soccer coach drove me over here and he said that they are playing indoor soccer.
Right. When was the last time you talked to them?
Christmas.
Right. And how was that arranged?
It wasn't.
Well, how did you talk to them?
I called my mother-in-law.
On a three-way call?
No. She happened to have that.
Oh, she had that.
Yeah.
So how are they doing?
They want to see me.
I'm sure they do. I'll consider any motion that you may have along those regards as well, Mr. Locke.
Yes, Your Honor.
I noticed this, Miss Gigandis, is that right?
Yes, sir.
Is that close enough or is that right?
It's close enough.
All right. Mr. Locke has filed some motions for discovery. Does the Commonwealth Attorney's Office have an open file policy here in Christian County?
We provide discovery, Your Honor, and we have provided all the discovery we have at this point to Mr. Locke.
Is that consistent with an open file policy or not?
You know, I'm not actually sure.
Okay, do you have to file motions for discovery, Mr. Locke?
No.
Judge, I don't think anywhere that I practice requires it, but as a matter of practice, I always file a written request pursuant to the criminal rules to protect my record.
Sure.
But I have received, I will acknowledge that I have received by email dated February the 25th, I received an offer and I received discovery as well. There's a statement that Mr. Gandit is going to look into whether or not there is any dash cam or other type of audio or video recordings, and she's going to get back with me on that. But this is what I've received as a discovery, and I will be sharing that complete copy of that with my client today.
All right, thank you.
It's our practice to provide by email everything we have, and as long on the lines of the dash cam that I mentioned to Mr. Locke, I actually spoke to the deputy who transported Miss Adams, and he advised me that he was in it's called a pool car, so it wasn't specifically assigned to him, so there is no dash cam from this. However, in speaking with Mr. Adams, he has advised me last night that he has some videos and pictures, and I explained to him that I need those so I can disclose them, and he will be providing those to me.
If
I'll pass them on.
if you have any trouble getting that, let me know, and I'll certainly issue a subpoena and a court order for Mr. Adams to turn that over.
Okay, and then one other thing, my entry of appearance was included in the email to Mr. Locke. I didn't know how to get this to you, so this is the court's file.
All right.
I mean, copy.
All right, I have, Ms. Gigandit, thank you. Let me tell you how this is going to work. Whatever you file your original pleadings with the clerk here and send me a copy. I'm also available by email, and that's at it's a standard email address. It's jweathington@kycourts.net.
Yes, sir.
And you can send me some pleadings if we're going to have a telephonic conference. Let me know if you have any discovery problems, Mr. Locke, and we'll take those up. It doesn't sound like you're going to have any of those problems. I will do telephonic conferences unless you, Mr. Locke, determine that it's, or you and I determine that it's a crucial stage, and we'll try to work around Ms. Adams' presence. And I'm changing the bond on your client to $50,000 full cash.
And I would like to express, Your Honor, I talked with the Mr. Adams last night, and we discussed this issue of bond, and he expressed to me that he's extremely concerned about the safety of his children and himself, and so for our position, we would oppose any modification, as we're very, very concerned, especially considering Ms. Adams' issues with addiction, and so our position is that we are opposed.
Right, and that's why I want any motions that you may file. I want the Commonwealth to be advised about that. We'll have a hearing.
Yes, Your Honor.
Have some conferences. Anything else you need today?
I'm a little unclear, Your Honor. I thought I heard the court say initially I heard you say you were going to keep it at 10,000, and then I heard you say you were going to change it to 50.
That's right.
Then I heard the Commonwealth say they're opposed to a modification. So I want to make sure, obviously this is a very important case for me and my client.
Yes.
I want to make sure that I make a complete record here. Is the Commonwealth opposed to you changing it from 10 to 50? And I would also ask the court for, it's my belief, with all due respect to the court, that the court can't change the bond without notice and motion. Now, I will tell you, Your Honor, that I've had $10,000 in my escrow account for some time and could have posted her bond.
Right.
She has chosen on her own accord to stay incarcerated, one, for her sobriety, and two, there's other reasons. I'll just leave it at that. But I'm confident in telling the court that the reason she's not here today in civilian clothing and out on bond is because she, along with her consultation from me, has chosen to stay in custody.
Right.
Because she could have posted the $10,000 cash bond. So I don't believe that it's necessary for the court to change it to 50. I don't anticipate that even if you leave it at the 10, she understands the situation she's in. But I would respectfully ask the court, if you are going to modify it without notice, that you make some specific finding of fact as to why you would do that.
Right.
And I'd like to clarify, I'm sorry, I misunderstood earlier, so I thought that there was a decrease in the bond, so I've created an issue that was not an issue. So
No, I don't think you
take
did,
it back.
because had you not brought it up, I was going to change it anyway. And my experience, the court's experience with Ms. Adams, is that she will not abide by previous orders of this court. Consequently, I'm making a finding that she is not suitable candidate she can't be supervised, and there are not adequate facilities in the community to adequately supervise her based upon her prior performance before this court. She's violated several court orders. She's violated specific court orders about contact. I appreciate the fact that she wants to stay in custody, as you said, Mr. Locke, but if she's going to be released, I want to have a hearing on it with specific conditions, and I will consider those conditions. But as a precaution, I'm changing the bond to $50,000 for those reasons, so that I can ensure that I have that hearing without her being released.
And that was 50,000 full cash?
50,000 full cash.
I apologize for the confusion, Your Honor.
Nah, I confused you all. I confused both of you, and Mr. Locke is correct. I was getting ready to make those findings, but I'm glad that you notify the court those findings being made. Anything else I can do for you?
Your Honor, I would just tell the court I have filed also a motion for a bill of particulars pursuant to Rule 6.22. I would ask the court to just hold that motion in abeyance.
Okay.
If there is no need for me to renew that motion or to ask the court for a specific ruling on that, then I will file a renewed motion if I believe the court needs to make a ruling, but I would just ask the court to hold that in abeyance until I've had a chance to look at the discovery.
Great, and I'll be happy to consider that issue by telephonic conference if it becomes necessary.
Yes, Your Honor.
Right. Anything else, Ms. Chiquita?
No, sir.
Mr. Locke?
Is the court going to set a telephonic conference now, or what is the court's pleasure as far as a next
I
proceeding?
want to see how you do with discovery, how you talk to your client about the possibilities. I've opened the door for you about bond conditions and long-term rehab out of state. I will consider that, so I'll leave that to you. When you need a telephonic conference, I'll accommodate you in swift fashion. I'm from Davis County. Davis County, we just started our family court. We haven't had one before, so I have some additional time. The problem is for the month of March, I'm getting ready to start my trial term tomorrow, and I have a trial tomorrow. So every other month I'm in trial, but as you all know, most of the time that doesn't happen. So if you file a motion in need for my appearance or need her presence, I will swiftly set a hearing or set a telephone conference for you.
Yes, Your Honor, we understand.
Anything else?
Nothing from the defense.
All right, thank you very much.